Hi, and welcome to Platforms Training Academy. My name is Charles Young, and today we're going to talk to you about the Illinois Concealed Carry Law. Hopefully today we're going to break down Illinois Concealed Carry Law for you so that you can have a better understanding of what to expect when you leave one of our classes. So, just a quick disclaimer, I'm not an attorney, so if you have any real discrepancies about what you're about to hear, please consult with an actual attorney. But I'm still going to do my best to try and explain this to the best of my ability. So as we're doing this, we're going to do this as if we were in a class. We're going to go through the PowerPoints. I recommend that when you see a new PowerPoint, pause the video, and then from there, read the slide, resume the video, and then listen to our explanation. We're not going to read every slide verbatim, so kind of follow along with us. If you have any questions throughout this, make sure you leave your questions in the comment section below. So let's get started. First thing we're going to talk about is the FOID Card Act, then the Concealed Carry Act, and finally, the Justifiable Use of Force. So the first item we're going to talk about is the FOID Card Act. And on this first slide, the requirement simply states that in order for you to possess a firearm in the state of Illinois, you need to be in possession of a FOID card. This next slide simply states that in order for you to be in possession of ammunition, you also need to be in possession of a FOID card. So firearms and ammunition require the possession of a FOID card in the state of Illinois. In order for you to transfer a firearm or firearm ammunition in the state of Illinois, the person in which you are dealing with needs to display a currently valid FOID card or a currently valid license to carry a concealed firearm. So if you're selling a firearm to someone in the state of Illinois, the person that is buying the firearm needs to have a FOID card. If you are lending a firearm to someone for said purpose of just going to the gas station, that person needs to only have a concealed carry permit. It is understood that if you have a concealed carry permit, you also have a FOID card though. The requirements to get a FOID card in the state of Illinois start with being 21 years of age or over. If you're not 21 years of age, then you need parental consent to get you a FOID card. Also, the parent must have a FOID card as well or not be prohibited from getting a FOID card. Also, you could not have been convicted of a felony anywhere in the United States, or be addicted to narcotics, or have been a patient in a mental health facility within the past 5 years. You also have to not be a person with an intellectual disability or an illegal alien currently in the United States, and you also cannot have an order of protection against you. You also cannot have been convicted within the past 5 years of battery, assault, aggravated assault, or any violation of an order of protection, or anything similar in any other jurisdiction, which means anywhere in the United States. This second part of this slide simply states that if you're involved in any type of domestic violence, you're not allowed to have a firearm anywhere in the U.S., so you will not be allowed to get your FOID card here in the state of Illinois. Revocation of your FOID card. So if the state police deny or revoke your card, they have to give you written notice via the mail stating why they deny or revoked your card. Once you get that revocation notice, you have 48 hours to do a few things. The first thing is to surrender that FOID card to the local law enforcement agency where you live. So if you live in the city of Chicago, you will be turning that card over to the Chicago Police Department. Also, you will be completing a firearm disposition record stating where you have left your firearms. You can leave your firearms with the Chicago Police Department or that local law enforcement agency, or you can leave your firearms with a person that is currently in possession of a valid FOID card. If for some odd reason you fail to comply with this subsection, when that card is revoked, the state police or any local law enforcement agency can get a warrant issued to come and seize said FOID card and any firearms in your possession. The observation of that FOID card is also grounds for an arrest if you did not turn in that card within that 48-hour period. So a quick recap, in order for you to be in possession of a firearm or ammunition or to purchase either one of those items, you need to be in possession of a FOID card. Understand that there are exceptions for people that do not live in the state of Illinois. The next item, the Firearm Concealed Carry Act. Issuance of licenses to carry a concealed firearm. So the requirements to get a concealed carry permit in the state of Illinois start with you being at least 21 years of age. You also have to have a currently valid FOID card. You also could not have been convicted or found guilty anywhere in the U.S. of any of the items that we're going to list going forward. The first one being any violent misdemeanors within the past 5 years. 2 or more violations related to driving while under the influence of alcohol, which are DUIs. You also cannot be the subject of a pending arrest warrant, prosecution, or proceeding that could lead to you not being able to own a firearm. What this means is if you're in the middle of an investigation or a court proceeding for an event that could lead to you not being able to have a firearm, the Illinois State Police will prematurely revoke your card and ask that you turn that card in until the issue is resolved. This slide states that within the last 5 years, you cannot be a documented alcoholic or drug addict. Next, you have to complete any of the firearms training requirements that are listed by the state and submit any of the requisite fees and not be a danger to public safety. Your license, once issued to you, shall be valid for a period of 5 years, and this license will allow you to carry a loaded or unloaded concealed firearm on your person or inside of a vehicle on your person. So what that simply means is your firearm, when you leave home and you're carrying it in public, you can carry that firearm completely loaded as long as it is concealed. If you are carrying a concealed firearm anywhere in the state of Illinois, you need to be in possession of that concealed permit unless you are on someone's private land, i.e. your private land, your home, or anywhere that you actually own property. Or if you're at a fixed place of business, meaning you're at work and your job is not a mobile item, i.e. a food truck, or if you're on someone else's private land with that person's permission. You also do not need a concealed carry permit if you are acting in the duties of the police, a military member, or a security officer in the course of their actual duties. You don't need a concealed carry permit if the handgun is broken down into a non-functioning state, is not immediately accessible, or is unloaded and enclosed in a case. In any of these 3 conditions, you still need to be in possession of a FOID card. So, the most common way to carry a firearm with a FOID card and no concealed carry permit is going to typically be unloaded and enclosed in a case, meaning the firearm is inside of a closed case and that said firearm is unloaded. Hopefully you've taken a second to pause the video and read this slide, because this slide talks about interaction with the police. And very simply stated, if the police stop you for any reason, you do not have to disclose any information about firearms unless the actual police officer requests information about the firearms. So, if the police pull you over for a traffic light violation and you have firearms in the vehicle, it is voluntary to disclose that information unless the police asks, are there any firearms in the car? At which point you are legally obligated to honestly answer that question. When the police ask, do you have firearms in the car, they may also ask, where is the firearm? You have to let them know where it is at and allow them to secure that firearm if they want to for the duration of that stop. Also, if you're a passenger within a vehicle where you're being pulled over and the police ask about firearms, you also must comply with the requirements of this section, meaning that if they ask about firearms, you as a passenger have to also honestly answer that question, even if it's not directed at you. This next slide goes more into first responders. If a first responder, for example, a firefighter, paramedic, or an EMT, or a police officer makes contact with you, during the time of that contact, that personnel may actually take your firearm for you while they are rendering aid to you or giving you any type of service. This is not a time to be combative towards first responders. During this time, if a first responder asks, hey, I'm going to take your firearm off of you, do not fight them. Let them secure the firearm. Once these first responders have completed any contact that they need with you, if you are mentally and physically capable of possessing said firearm, they will give you your firearm back. In this instance, if you are transported to, say, a hospital, the firearm shall be turned over to the police, at which point you will get a receipt stating that your firearm is taken and any information about the firearm and where to retrieve that firearm once you leave the hospital. License renewal. Your license is good for 5 years. At that 5-year mark, you will need to complete a 3-hour refresher course to renew your concealed carry permit. If you change your name or address, you have 30 days to alert the Department of State Police that you have changed your name or address and issue a notarized statement saying that you changed your name or address. On the other hand, you only have 10 days to report to the state police that your license has been lost, destroyed, or stolen. If your license has been stolen, you need to report that to the police, and when you go to get a new license, you need to have that police report. Prohibited areas. Anywhere that you cannot carry a concealed firearm, and these locations are going to include any building, real property, and parking area under the control of any of these locations. The first one being a public or private elementary or secondary school, which is anything that's kindergarten through 12th grade. Then on the other side, you have preschool or child care facilities. Even a home-based child care facility is going to count as a child care facility. So, as the owner of that home, during the time that the home is a child care facility, you or anyone else cannot conceal carry inside of that home. Officer of the executive or legislative branch of government. So typically, any elected officials, you will not be allowed to go into their offices with a concealed firearm on you. You cannot conceal carry in any court in the state of Illinois. You also cannot carry a firearm on any property that is owned by a local government, whether it be city, county, state, or federal. You also cannot go into correctional institutions or detention facilities such as Cook County Jail with a firearm on you. You cannot go into hospitals or any of their affiliates such as clinics or mental health facilities or even nursing homes with your firearm on you. Also, you cannot conceal carry on public transportation. But if you use public transportation to get back and forth from the range to your home, you can transport that firearm on public transportation as long as that firearm is unloaded and enclosed in a case. This slide talks about events such as block club parties, which are common in the state of Illinois, more so Chicagoland area, where you would use a permit to block off a public area for, say, a party. During the time that that public area is being blocked off for that party, you cannot conceal carry inside of that blocked off area unless you are going to your home, place of business, or vehicle and you're simply passing through to get to one of those three said items that I just mentioned. This is similar to the last slide. The only difference is it's not blocked off. So with that being said, if you were to go to a location where you were on public property and they were selling alcohol for a certain period of time, you could not be a part of that event with that concealed firearm on you during the time that alcohol is being sold or served. You cannot conceal carry inside of public parks, playgrounds, or any type of athletic facility that is under the control of a municipality or park district. This is typically to protect children. Understand that you can pass through these locations as long as you are, as I said, passing through, i.e. you're on a trail or a bikeway that passes through that location to get you to your destination. But you cannot stop inside of one of these parks or playgrounds and get on the swings or set up a picnic while you have that firearm on you. You cannot conceal carry inside of the Cook County Forest Preserve District as of right now, but there is legislation in the works to remove this from the laws. Public or private community college, college, university, so any post-secondary educational institution such as the University of Chicago, Northwestern, UIC, you can't go into any of their property with a concealed firearm on you. The next one states that anywhere that gambling is going on, you cannot take a concealed firearm onto that property. Collegiate or professional sporting events. So sporting events such as the Bulls, the Bears, the Blackhawks, or even sporting events for the University of Chicago or the Northwestern Wildcats or anything of the sort, you will not be allowed to conceal carry during those events. A little out of order here, the public library, amusement park, zoo, or museum. This is typically where you're going to see a lot of children at, so it's safe to understand why you would not be allowed to conceal carry in any of these locations. Airports, you cannot conceal carry inside of an airport. But understand, if you are traveling with a firearm, there are rules and regulations that govern traveling with a firearm, and make sure you follow those rules very strictly. Bars, you cannot go into a bar with a concealed firearm on you. Understand though, if you were to go inside of a restaurant that happens to have a bar inside of it, as long as you don't go to the bar itself, you're not technically at the bar. You can sit down at a table inside of the restaurant as long as you're not being served open alcohol inside of that restaurant. So make sure that you understand that you cannot go to a location that is simply a bar, or you cannot go into a restaurant and go to the bar and sit down with your concealed firearm on you. The Federal Nuclear Regulatory Commission has locations all throughout the state of Illinois. You cannot bring firearms, ammunition, or any type of weapons onto their property. That is to include concealed carry or transportation of any firearms or dangerous weapons at all. Anywhere where firearms are prohibited under federal law, i.e. a military recruiting station or the post office, they will have signs posted on their entrances stating that federal law prohibits firearms on the premises. The sign that you see below is a sign that you're going to see on most of these locations. But understand that if these locations in this piece does not have a sign on it, it still applies to these locations, even without the sign. So if you are the owner of property, you can post these signs on your private property. If you are in a private residence, you do not technically need the sign, but if you wanted to, you could put the sign up to state that you do not want concealed carry on your property. This slide talks about the parking lot exception. Before we get into it, understand the parking lot exception does not apply to locations that are governed by the Federal Nuclear Regulatory Commission. Any of the other locations, this exception does apply to. You can carry your firearm into the parking lot area of a prohibited location as long as you do not get out of the car with that said firearm. There's only one reason that you're allowed to get out of the car with that firearm, and we'll talk about that in the next slide. But let's take, for example, if you were to go to a school to pick up your children, as long as you don't get out of your car, you can pull up to the school, pick up your children, and then drive away without ever having to unload or take off your firearm. But if you were to get out of the car to go into the school, you would need to take that firearm off before you ever exited the vehicle, and then you would need to take that firearm and lock it in a container out of plain sight inside of a locked vehicle. The only time you are allowed to take that firearm out of the vehicle is if you are going to store that vehicle or retrieve it from your trunk. Understand though, that firearm needs to be unloaded before you leave the vehicle to store that firearm in the trunk, and that firearm should stay unloaded when retrieving it from the trunk until you get back in the vehicle. Case includes any of the items listed here, such as your trunk or firearm carrying box, shipping box, or other container. As we mentioned before, you will not be in violation of the law if you are passing through one of the prohibited locations, as long as it is not a location that is governed by the Federal Nuclear Regulatory Commission. So if you were to pass through the Cook County Forest Preserve District, you would be perfectly fine to keep your concealed firearm on you as long as you don't stop and set up a picnic or go bird watching inside of the Forest Preserve. Just make sure you continue to pass through. If at any time someone gets an order of protection against you, the state of Illinois will deny or revoke your concealed carry permit. So this slide talks about the use of alcohol and drugs when it comes to firearms. A good way to remember this is what you can't do with a car, you can't do with a firearm. So if you can't drink and drive, you cannot drink and carry. If you cannot smoke and drive, you cannot smoke and carry. But if you were to go into a bar without your firearm on you, you could technically leave the bar after having a few drinks and get back in your car and drive away, which means that you can go into the bar without that firearm, have a few drinks, come back out and put your firearm back on, as long as your blood alcohol content level is below the legal limit, which is 0.08. Just like we mentioned in the FOID card portion, you have 48 hours after receiving a notice of revocation to turn that card over. If you do not turn your card over within that 48-hour period, the police will issue a warrant to come and search your house for that card, the firearms, and for the person in possession of that card. So with that being said, a quick recap on the Concealed Carry Act. Very simply put, once you have your FOID card, then you're allowed to get your concealed carry permit. That concealed carry permit, very simply put, will allow you to carry a loaded or unloaded concealed firearm on your person or on your person inside of a vehicle and anywhere where you're not prohibited from carrying, as mentioned in the prohibited areas section of this law. If you have any questions about that at this point, please remember to put your comments in the comment section below. The next one is the Criminal Code of 2012 as it relates to the justifiable use of force. So the first thing we're going to talk about is the definition of aggressor. And very simply put, this is 2 slides. So take a second to look at this slide, and then we will resume and go to the next slide. Now that we've read these slides together, very simply put, think of yourself in a kindergarten class, and there's Tommy and Timmy. And Timmy slaps Tommy, Tommy slaps Timmy back, and they both run to the teacher screaming and hollering, saying, "Hey, he slapped me. No, he slapped me." The teacher's going to typically ask who slapped who first. So right there you have the definition of the aggressor. The person who initiates the unlawful use of force is typically going to be the aggressor. The aggressor cannot use your self-defense as a reason to go above and beyond when they are assaulting you. With that being said, if for some odd reason the aggressor initiates contact with you and you defend yourself, but you defend yourself much better than the assailant expected and they try to withdraw from contact with you, at that point in time, you should cease contact with the assailant. If you were to continue to use force against the assailant as they are trying to get away from you, at that point in time, you become the aggressor. So use of force and defense of person. Before we get into this, understand that there are 2 levels to force in the state of Illinois. There's force, as you see here, indicated by the words use of force, and then there's deadly force, which will be indicated by the words force that is likely to cause death or great bodily harm. So in this slide, we're going to talk about basic force. Use of force in defense of a person simply states that if at any point in time an aggressor initiates contact with you without provocation, you're allowed to do what you believe is necessary to defend yourself or someone else against that aggressor as long as the force you are using is reasonable. This next slide is going to take us into the realm of deadly force, which is indicated by the words force which is intended or likely to cause death or great bodily harm. This simply means that if at any point in time an aggressor initiates contact with you in the form of deadly force, you are allowed to stop that person from using deadly force against you if you deem it necessary and someone else would deem it reasonable. So let's go into this a little bit further. Understand that great bodily harm in the state of Illinois is going to be constituted by loss of consciousness, permanent disfigurement, and broken bones. The death part is fairly straightforward. If somebody is doing anything that could cause you death at that point in time, we are well within the realm of deadly force. If you have any questions about that, please leave those questions in the comment section below as well. So forcible felony is here because it is mentioned in the previous slide, and it states that you can use deadly force to prevent the commission of a forcible felony. So the 2 obvious ones are going to be first degree and second degree murder. And then you have predatory criminal sexual assault of a child, which is someone raping a child, or aggravated criminal sexual assault or criminal sexual assault, which again is someone raping another person. Robbery is when someone is taking something from you via force. But understand that you have to know the difference between being able to legally use deadly force and when you should use deadly force. There's a concept called never draw on a drawn gun. If you don't know what it is, make sure you look it up before we go into this idea of I can use deadly force to stop a robbery. Burglary is when someone breaks into a location or remains inside of a location with the intent to commit a felony. Residential burglary is that same definition, but only at a residence. So, with that being said, understand that you can use deadly force to prevent the commission of these type of forcible felonies, but it's very hard to articulate in any of these given scenarios why you use deadly force if you were to go and say, this guy burglarized my house, he had my TV in his hands, so I shot him. That wouldn't look very good in front of 12 people that you've never met a day in your life. So make sure we do our research and understand where we draw our line in the sand when it comes to using deadly force. The next one is aggravated arson and arson, which is typically setting things on fire or using explosives to destroy items that have a value of $150 or more. Typically, we're not going to use deadly force to protect things that can be replaced. That is a mantra that we live by here at Platforms Training Academy. I hope that you would take that home with you as well and understand that we only use deadly force to stop deadly force, not to protect our money. Aggravated kidnapping or kidnapping. If someone is trying to abduct you or a child of yours, at this point in time, you are allowed to use deadly force to prevent that. Aggravated battery resulting in great bodily harm or permanent disability or disfigurement, and any other felony which involves the use of threat of physical force or violence against any individual. So at this point, pretty much doing anything with an immense amount of violence. At that point in time, you can use deadly force to stop that, because typically we're going to be protecting our life at that point. Dwelling comes up because in the next slide we're going to talk about defense of a dwelling. So your dwelling is where you actually live or within a reasonable amount of time intend to live. So use of force in defense of dwelling. Very simply put, you can use basic force to stop somebody from illegally entering your home or attacking your home. So if you are entering your home and someone follows you into your home, you can use basic force, not deadly force, to stop them from entering your home. Once we get into the realm of deadly force as it pertains to defending your dwelling, there are two criteria that must be met before you can use deadly force. The first one is the entry must be made or attempted in a violent or riotous or tumultuous manner, meaning that someone has kicked your door in, they're coming into your house with multiple people, or they're entering your home through a way that they shouldn't be entering, i.e. the chimney or the doggy door or the windows. Also, the other criteria is that you must reasonably believe that such force is necessary to prevent an assault upon or offer of personal violence to you or someone else inside of the dwelling, right? With that being said, an assault upon is simply putting someone within reasonable apprehension of receiving a battery, meaning you are threatening them or making them think you are going to batter them. Battery is when you make physical contact with someone. The offer of personal violence is simply having tools that allow you to inflict violence upon someone. So entering someone's home with a firearm or a knife is an offer of personal violence. At that point, once you have met both criteria of violent, riotous, or tumultuous entries, and you believe that force is necessary to stop an assault upon or offer of personal violence, then and only then are you allowed to use deadly force to defend your dwelling. But to break that down into simpler terms, these two items come together very quickly in real life. So when you look at it from a realistic standpoint, you're not really defending the dwelling at that point. You're typically going to be defending someone's life in that instance. So keep that in mind. Use of force in defense of other property. So other property is going to be considered anything that you own that is not a dwelling. So if you are defending a home, that is considered a dwelling. Things like your car, your boathouse, or an apartment building that you may own that you don't actually live in is going to be considered other property. At which point you can use basic force to defend. And in these instances, we're defending against things like trespassing or torturous or criminal interference with that property, i.e. someone is spray painting the side of your building with graffiti, or they're breaking the windows on that building. You can use basic force to defend that dwelling, not deadly force. In the realm of deadly force as it pertains to other property, you can only use deadly force to prevent the commission of a forcible felony, which we went over earlier. So when you are defending other property, the only time you're allowed to use deadly force is to prevent the commission of any of the forcible felonies that we mentioned earlier. So with that being said, a very easy way to put this into perspective is what we like to say: we do not want to use deadly force to defend things that can be replaced. The only time we typically want to use deadly force is to defend our life or somebody else's life or their livelihood, meaning something that will affect their lives gravely, i.e. chopping someone's arm off or beating them until they're unconscious, or permanently disfiguring someone's face or body to the point where they're not going to be the same. You should not ever be in the idea of, I'm going to use a firearm to defend my car or my shoes, even though that is a hard pill to swallow. It's something that we all need to think about. So with that being said, hopefully we've answered most or all of your questions. Again, if you have any other questions about what we just went over, please leave your questions in the comment section below. Until next time, I'm Charles Young. This is Platforms. Stay safe.